Welcome. We're here with CGRS Legal Director Blaine Bookey to discuss a recent decision out of a federal appeals court reaffirming that domestic violence survivors can qualify for asylum in the United States. Before we get to last Friday's ruling in the case of Pena-Paniagua v. Barr, Blaine, can you tell us what was at stake in this case?
Absolutely. Thanks, Brianna. And I'm excited that we're have this new segment here at CGRS. So over the last 3 years, and under the guise of the current public health crisis, the Trump administration has eviscerated the US asylum system that for more than 40 years provided safe haven to men, women, and children who are fleeing really unimaginable horrors. And women in particular have really borne the brunt of this administration, which has tried to bring us back to a time before women's rights were human rights. And at a moment when gender-based violence is on the rise and women's lives are at ever greater risk, the United States is now closing our doors. And the result is that women are being sent back to the lion's den where they face violence and even death.
Blaine, can you tell us the backdrop for last Friday's decision out of the First Circuit Court of Appeals in Pena?
Yes, I'll do my best to be brief. This area of the law really has a long and a winding road through multiple administrations. But in 2014, the US's highest immigration court, known as the Board of Immigration Appeals, issued a ruling saying that women escaping brutal violence at the hands of their husbands and other partners in countries where their own governments have turned a blind eye can qualify as refugees under US law. This decision was the culmination of nearly 2 decades of litigation and advocacy by our center and collaborators across the United States, and really represented an important advancement in the recognition of women's asylum claims. But then in 2018, then Attorney General Jeff Sessions inserted himself into the issue. And in a case that's known as Matter of AB, he overruled that precedent from 2014, and he all but instructed immigration judges to now reject these claims outright without even considering their underlying circumstances or individualized facts.
What have been the ramifications of the Attorney General stepping in with Matter of AB?
As I mentioned, this area of gender asylum law, in particular for domestic violence survivors, has been contentious. But before Sessions' decision in the Matter of AB case, both advocates and government agencies alike had at least come to some agreement that women fleeing domestic violence could, at least in theory, qualify for protection, so long as they produced sufficient evidence to show that their risk of persecution in their home country is well-founded. The Attorney General completely upended the law, causing confusion and leading to many women being ordered deported to their deaths without receiving their fair day in court. As some judges have interpreted AB exactly as the Attorney General intended, as a complete ban on cases involving domestic violence.
And now to last Friday's decision. What did the court say and what is its significance?
Sure. In Ms. DePena's case, the lower court, the Board of Immigration Appeals, had denied her claim by deferring to Matter of AB and refusing to consider any of the specific facts and evidence that Ms. DePena had presented that substantiated the years of abuse that she had experienced in her home country of the Dominican Republic. The First Circuit in DePena overturned that denial and held that the lower court erred by not giving meaningful consideration to Ms. DePena's individualized circumstances and facts when deciding whether she was a member of a protected group that could qualify for asylum. And under US asylum law, to be eligible, you have to show that the harm you experience would be on account of one of these protected grounds. And in her case, that ground was whether she was a member of a particular social group. The other grounds are race, religion, nationality, and political opinion. That case, the specific legal question in DePena that was before the court related to this particular social group ground that she had advanced and said that it could be recognized. But the case also stands for something much broader. The court decisively recognized a fundamental principle that had been the law of the land before Sessions intervened, that women are a protected group and that they are persecuted in many countries precisely because of their gender and their status as women who are subordinated in society. And although not all women who experience persecution will be able to satisfy the many stringent requirements for asylum, even after this decision, the court really recognized that there is no basis in US law to slam the door in their face before they had even had a chance to knock.
So can you tell us what's next for Ms. Pena and other women like her?
We're thrilled that Ms. Pena and other women like her will be given the chance to have their claims heard by judges who must evaluate the evidence fairly and not prejudge their claims or discriminate against them. We're also hopeful that this decision is just the first and that other jurisdictions will follow suit. We appeared before the Ninth Circuit Court of Appeals last month in a case raising very similar issues, and we will continue to show up in court until the unlawful AB decision is erased for good. Outside of the courtroom, we are continuing to draw attention to these issues, and we invite you to visit us at immigrantwomen2.org to learn more and to take action in support of safety and justice for survivors like Ms. Pena. If you're an attorney who's representing a survivor in their asylum case, please let us know how we can support you by visiting us at this website. Thank you for tuning in.